Hi, good evening. This is a Delhi High Court judgment under Negotiable Instruments Act. It is Glass Brew Trading Private Limited versus Orbis Trusteeship. So the facts are very briefly. Glassbrook approached hereafter I will say GB. GB approached the debenture holders seeking finance of rupees 150 crores. So RBs agreed to act as a debenture trustee. They issued 13 checks. There was a default in payment. So simply put, debenture they sought debenture finance by way of issue of debentures for 150 crores. Somebody agreed to act as a trustee, and 13 checks were issued. This is the simple fact. There was a default in payment. So some dates are very very important. So please carefully note. 28 to 2022 checks were dishonored for insufficient funds. 11/3/2022 demand notice was issued by the company by way of an email, that is Orbis. By way of an email, they send a demand notice. 11/3/2022. 12/3/2022 to 26/3/2022, the notice period of 15 days, because they generally give a notice and then say you have to make the default good within 15 days at that time. Now it is 30 days. Then 27/3/2022 is excluded. The limitation for filing the complaint commences from 28/3/2022. Last day is 27/4/2022 for filing the complaint. The Orbis filed the complaint on 28/4/2022. So this is very very important. Otherwise, you will not understand the case. I am not going to repeat it. Now the issue is subsequently what the Orbis did was they issued a notice by registered post and by courier after sending it by email. So whether the limitation period can be increased or not, that was the question. And the court says no, no. Once you have sent the notice by email, that is a valid service. There is no need for you to send by registered post, and you cannot postpone or increase the period of limitation by sending it by registered post. Then one more additional fact is the RBs filed a complaint in Gurgaon court. So later they have withdrawn it and filed in the Delhi trial court. Two issues were there. One is when limitation commences for filing the complaint. That is one issue. Second issue is whether time spent in pursuing first complaint can be excluded. These are the two issues, main issues. So, second issue first, whether time spent in pursuing the first complaint, that is in Gurgaon court. I filed the complaint in Gurgaon court, later I withdraw and then file it in Delhi court. So, whether that period spent there, can it be excluded? That was the question. The Delhi High Court says, relying on a Supreme Court judgment, that Limitation Act will not apply to proceedings under the Negotiable Instruments Act. Hence, the limitation period cannot be excluded because you have filed it in a wrong court. That is point number one. So simply they have said that. Then the second question is when the limitation commences for filing complaint. So the court says there is no requirement to serve each director as complaint is against the company. Opportunity to draw, that is company, is good enough for those who are in charge of the affairs of the company. High Court, relying on the judgments of coordinate bench, said that service of notice on drawer is good service on directors. Now, if we note down, I have already said the dates, but if you see the dates, 11/3/2022 notice was issued. So The time for making the payment expires on 26/3/2022, 15 days. Then from 27/3/2022, limitation for filing criminal complaint starts. So one day you have to exclude. So by 27/4/2022, that 30 days time limit will end for filing the criminal complaint. Unfortunately, the company filed the Orbis filed the complaint on 28/4/2022 with 1 day delay. Exactly 1 day delay. So court said, Delhi High Court, the timelines are strict, but they are still condonable. It is a complainant who must have sought condonation and by providing sufficient cause before the trial court. But this Orbis did not file a condonation delay petition before the trial court for the 1 day delay, explaining why there was 1 day delay. So, because of that, the court held that this criminal complaint itself is invalid and it quashed it. That is the crux of this judgment. So, while filing 138 petitions, complaints, uh, both the advocates and the company have to be extremely careful. Otherwise, you will lose the chance of uh, putting the directors in the prison. That is very, very important. So, two important aspect is limitation act will not apply. So, you must see what is the jurisdiction, which court has jurisdiction, and correctly file the case in that court. That is point number one. Point number two, the limitation period for filing the complaint 30 days is very strict. So while calculating also, you have to be extremely careful. Even 1 day delay will result in dismissal of your complaint. Further, for most importantly, in case if there is a delay, it should be filed along with the condemnation petition. Otherwise, it will be quashed. That is the point which I want to make. Thank you very much. Have a great evening. Bye.